Hi, everybody. I want to talk about something that I've really shied away from for the last several years, and that's politics. But I feel the need to talk about what's going to happen at the Supreme Court tomorrow and talk about the difference between possible and probable. So, tomorrow, the former president is going to be arguing before the United States Supreme Court that the Constitution gives presidents presidential immunity to commit crimes. Criminal crimes, not civil, criminal. Now, the Constitution clearly says that there is immunity while a president is sitting as president. There is immunity from civil prosecution. And that makes sense. The civil is, you've done something to me that causes me harm. I might be eligible for compensation. You did something that made me lose my job, and I suffered losses. So we have a trial, and if you're found guilty, you owe me something. So that would be a distraction for a president. That makes sense. That's clear. And that's why it's in the Constitution, quite frankly. We're talking about something very different. We're talking about a criminal act. That is not in the Constitution. As I understand it, the argument is being made and was made in appellate court that it's an interpretation of the Constitution. In other words, it's not spelled out. And interestingly enough, or horrifyingly enough, in the appellate hearing on this case, before it went up to the Supreme Court, the three-judge panel, one of the justices actually asked the attorney for the former president, do you mean to say that a president could have their rival assassinated, which obviously is a crime, and they are immune to that? And the answer was, well, yes, they are immune to that. And then the judge followed up, probably by the way you would, and said, well, what is the remedy for that? I mean, clearly, it's inconceivable to think that we would have a system where just because someone is president, there are no consequences for anything they might do. And this is where it gets really interesting. The response was, well, in order for a president to be held, in this theory, to be held liable and have a consequence, first, the president would need to be impeached. And once removed from office, because remember, impeachment is just a political process to remove the president from office. And just as a reminder, the House has to bring up articles of impeachment. It has to pass. Then it goes to the Senate for essentially a trial. Certain percentage of senators have to vote guilty, and then the president is removed from office. So then in the hearing, they said the president would need to be impeached, go through that process, removed from office. Then the Justice Department, assuming it was a federal crime, or if it was a state crime, I guess it would be the state legal system, would charge, indict, and then try now former president and regular citizen for those crimes. Here's what I want you to think about. The difference between possible and probable. And here's what I mean. It's possible I could become president. It's within the realm of possibility. Is it probable? Oh, hell no. There's no way. No way Cameron Hoxie is ever going to be president. Possible, probable. So here's what we're looking at for the United States Supreme Court. Here's the question that is being asked and why I think it is astronomically improbable that they are going to rule that a president has immunity from criminal prosecution, as set forth in the argument in the appellate court, or really anything. So what they're really asking, what's being asked to the Supreme Court tomorrow is this question: can Joe Biden assassinate Donald Trump? Can Joe Biden abolish the Supreme Court? Can Joe Biden abolish Congress? Now, all of those things are criminal. But Joe Biden is also the commander-in-chief of the military. Could he use the military to walk in and lock the doors of the Supreme Court? Now, according to this theory that was put forward, well, he can do those things. But then Congress could impeach him, assuming there is still a Congress, and he could be removed from office, and then the Justice Department of whoever the next president, I guess it would be Kamala Harris, her new Justice Department could bring him up on charges, could indict him, bring him up on charges, try him, convict him, and then he would feel a consequence for any of those actions. Here's the thing. There are 100 senators. It takes 60 senators to vote guilty to impeach a president. So, if there are 40 senators who, like maybe the space laser lady from Georgia, if there are 40 senators who are more willing to kiss the ring and be close to power, president doesn't get impeached. Let's take an even more historically accurate and really easier thing for the president to do. Put 40 wives of senators in a concentration camp, in a holding cell. Maybe it's a really nice place. Maybe he takes over the Breakers Hotel in Palm Beach. Or hell, he could take over Mar-a-Lago and put 40 senators' wives or husbands. Confine them. Make sure their spouses vote the right way. I say historically accurate. Don't forget, in the 1930s, there was a democratically elected president, different label, but president in Germany. This is what we saw. I find it improbable that the Supreme Court is going to rule that a president has the ability and the right and the legal permission to do the things that are being argued before the Supreme Court. It would be the potential end of their own Supreme Court. I don't think it's likely to happen. Possible? Probable. Relax. Think it through. Stranger things have happened, but I just don't see it. It doesn't feel probable. We'll see tomorrow. Ciao.